Hey everyone, welcome to the show. I am JD Houvener, patent attorney and owner here at Bold Patents Law Firm. Welcome to this live Q&A session with me. Again, I'm JD Houvener. I'm the managing partner here at Bold Patents, and I'm going to be here weekly with you. If you're new to the program, I encourage you to give us a like, share this with your folks and friends on social media. We want to get this to be a vibrant, bubbling inventor community. I see we've already got some live viewers coming on already. So one of the first things I like to mention here in a brief disclaimer is that this is a open forum. This is not a confidential discussion. So please do keep those inventions, those confidential questions that may need a legal consult to yourself. This is the forum to bring up hypothetical questions, to talk about what might be possible in the patent process or questions you've been wondering about for a while. So the agenda for today is pretty straightforward. I want to be discussing our topic for the day, which is what is an office action, and showing you where that fits into the whole sequence of the patent process. And we don't have any guests today, so we'll be focusing on those avvo.com questions. So if you're an avvo.com listener and you have been given the link, you can feel free to fast forward to those questions, but I do encourage you to stick around and hear what the discussion is today about. I will go through those questions. Those are kind of pre-formed questions that I've already received. But if you have a live question, please ask away. I will make sure to prioritize those live questions as we get moving. All right, so what I'm going to do is pull up our flow chart. And so this flow chart kind of will give you a flavor for where office actions fit in, right, to this whole patent process. And before I get started on this, I want to show you and provide for you a link to schedule a free screening session, okay? And so a free screening session is with our firm. It's with a non-attorney advisor that if now is the time for you and you've been watching me, you've been watching and thinking about your invention, the time is now, you're ready to take action. I want to provide you a link to get started. So this is a complimentary session. It's 20 minutes just on the phone to see if now is the right time. So that right there is the link to schedule today, all right? And if you do that and if you're taking action, we're gonna give you a copy of this book right behind me, Bold Ideas, The Inventor's Guide to Patents. All right, well, let's get to the heart of the discussion here. I wanna show you the Bold patent process. And so I will share with you my screen and we'll get started. All right, here we go. So the patent application process, all right, is something that happens over the course of 1 to 3 years, you'll see, okay? And I like to say up to 3 years, and it could be even more, depending on how aggressively you move. So the first step, okay, one step at a time, is the patentability search and opinion. And this really answers the question in italics here, which is to patent or not. And the next step is a provisional patent application, which locks in your patent pending. And then moving on to the non-provisional patent application, where this is a formal application that's submitted for examination. Now this black, step D is where the USPTO will come in and an examiner will do their own search and examination. And that is when we see office actions, all right? Office actions means that an examiner has reviewed the prior art, meaning any publications that are available. And for some reason, whether it's novelty or whether they think your invention is obvious based on the prior art, or maybe they're just objecting to the way you've written the claims or structured your spec or the drawings, they've rejected it, a rejection. And so it can feel like, oh my gosh, I just got rejected. But this happens a lot, and on average 2 to 3 times before a patent application actually gets all the way to issue. So today we're going to focus on this step D. Of course, if you have any questions on the A, B, and C that comes before that, feel free to raise them, but just know that today I'll be focusing on this step D that happens after you file your non-provisional patent application, which can be a utility or a design patent application, even a plant as well, plant patent too, so don't forget that. Okay, let's see if we have any questions back here on the live stream. Not yet. Good deal. So we got 3 live viewers. Good to see you guys. Thank you for that like, by the way. What I'll do is I will show an example. Okay, I want to start with showing you the dashboard on the USPTO's website. Okay, and they publish this. I think they're required to every month, and it does have a little bit of a lag. So looking back to March of this year, you can see how long does it take for the office action, once you submit the application here at start for D, how long does it take for them to respond? And you'll start to appreciate why it takes 1 to 3 years. Their average, right, is 16 and a half months to respond to the first office action, okay? And they think that's pretty good because traditionally it's been almost 2 years. So it's a really huge length of time. It's a lot of idle time that we as patent attorneys have to just keep telling our inventors, we're waiting for the examiner. They've assigned an examiner. They're conducting their search. We're almost ready to receive an answer. And so it's quite a wait. So it's why we do encourage you to look into expediting. So there is a track 1 program that we allow, we have a petition for, and we can help you apply for the first action pilot cases or track 1. So look at this. On the track 1, this is, you basically pay an additional $1,000 or $2,000 to get eligible for track 1. So from when you have pendency to petition to grant final disposition. Let's see here, let me get to from filing to petition grant. So when you file the petition for track 1, and when they get their final when the USPTO says, yep, this is our final answer, it's actually less than 6 months on average. So we were looking at, on the previous page, 16 months, right, to hear back on the first one. They're saying you'll get to final disposition, meaning you'll get probably 2 office actions. You'll be able to have one back and forth with the examiner within half a year. So just really moving through very quickly. And so this is just being able to afford that additional $1,000 or $2,000 buys you a lot of time. So we have been recommending that for all of our inventors that come through. So that's sort of the timing importance of an office action. I wanted to pull up an example, and I kind of ran out of time prepping for this. So what I want to do is just show you kind of live how to go look up a patent. Again, I go here a lot, Google patents, and let's just pull up a patent by Apple. Okay, I'll just put in Apple, and the assignee actually is where I should put Apple. Okay, and I'll cross that out. Here we go. Here's a recent one, and I want to make sure we're looking at granted patents that are utility patents that have been granted in the U.S. You see those little drop downs I did there? They have got one that just got, and I want to do one pretty recently. So I want to say, oh, well, their priority date was 2018. Do we have any out there since 2018? Okay, creative camera. Let's take a look at this one. Apple's always got some very fascinating patents coming out. So this is 4 inventors here. You can see right from the cover page, and you'll see this is quite extensive, 314 pages long specification. All right, so this was issued December 31st, 2019. 4 inventors here, Di, Paul, Rick, Walt, and Scapel, and their applicant, obviously you can see they've assigned it to their company they work for, which is Apple. Okay, let's look at the abstract. You can get a sense of what the invention's about here. The present disclosure generally relates to displaying visual effects in image data. Some examples include visual effects including an avatar displayed on the user's face. In some examples, visual effects included stickers applied to image data. In some examples, visual effects include screen effects. Visual effects modified based on depth data in the image data. Interesting, so depth data. So perhaps modifying the environment around them. This makes me think of like Snapchat and the like. I kind of want to scroll down just to see some other images, and you guys can see this is probably, some of this functionality is what you might see years down the road. I like to always scroll down and look at the claims. You can see the claims just go on and on. This is quite detailed in terms of what it actually provides. You can see every single one of these elements displaying the visual apparatus in accordance with the determination of depth data based on the depth in the first portion of visual avatar. So a lot of detail in this, meaning it has a fairly narrow scope. What I want to do is focus on the office actions. And so how do you find out how this application fared when it was being prosecuted, right? When an examiner was looking at this invention. Well, you can take a look by just using this patent number, okay? So I'm just going to copy this patent number, and you go to the system called PAIR, P-A-I-R, and that's the Patent Application Information Retrieval System, okay, P-A-I-R, and you can look up by patent number, okay? Just select patent number here, and you can leave, I believe, leave the comma. I like to take the commas out. I don't think you want the commas in there. Uh-oh, and this does happen sometimes. This is great. You know, this is the USPTO on their site. Okay, it did come through. That's nice. Okay, so right here, this gives you a lot of information right from this. And this is open to the public, all right? Anyone can look at this. It's not just for patent attorneys. Again, similar information. You can see all the inventors here, Apple here. This is the application number. It's different from the patent number. What you can do also is look at the image file wrapper. And this is where you're going to see the whole prosecution history file wrapper and see what happened. Okay, so I like to scroll all the way down to the bottom. You can see that this was originally filed. Okay, originally filed. They did a track 1 request. Okay, I just mentioned that earlier. That's interesting. And that's why it probably got through so quickly. So they submitted it in September 26th, 2018. Okay, that's when they first submitted September, and it got issued just a year later, right? In October 2019, and that is screaming fast. I think we saw they paid their certificate. You actually got it granted December 2019, so it's very quick. Just over a year is very fast. So you can see the track 1 was granted right here. So there's a petition, and then it was granted. And if you go up here, you can see that there was provided some non-patent literature, and this is the examiner that will cite these non-patent literature documents. I want to try to get up to the actual non-final rejection. There's a lot of NPL, non-patent literature cited. And I'm going to try to find out where this... Okay, non-final rejection. That took me a little while. So this is the actual rejection itself. And what I want to do is pull up this document and simply look for that non-final rejection. That sort of means the first rejection. It's 16 pages. You can see that here. So you can click on this little button, the check mark, scroll up to the top, and get the PDF. And that way you get all 16 pages. If you just click on that link, it'll just give you the cover page. Okay, so let that come up. I will open up the document. And we're going to go to that file we just downloaded. Let's see, where did that go? Maybe it went inside here. Yeah, it did. Okay. Okay, let's take a look. I know we're taking some time here, but this is important stuff. Because I want to make sure you understand and appreciate what an office action is. So this is the application. It was still pending. They filed it September 2018. This is the first office action, so they're notified of it February 28th, 2019. Okay, so it took them, what was that, 5 or 6 months, okay, which is about what we saw in that earlier chart. That's about average, okay, when on a track 1. If you don't do track 1, that could look like a year, right? It could be this, 2020 is when they might have heard back. So let's scroll down and see what is attached to this. So this is the office actions summary, and the examiner's name is here, Salam Gabriel. And you can see that there's a status there, and they're saying this is non-final, meaning that they haven't come up with a final decision. And they're saying, okay, what happened? So of the claims, and we didn't get to look at many of the claims, but they outline 1 through 13 and 15 through 55 are pending. So for some reason, it looks like claim 14 during that prosecution history had been canceled or withdrawn. They list all these separate claims, 1 through 2, right? This whole set of claims, and they're skipping 11, 14, 23 through 28, right, are rejected. And then the others are objected to. So it's a great example to kind of say what's the difference. And rejected means, as we'll see below, that there's something legally wrong, meaning there's novelty or non-obviousness concerns, meaning we're not going to allow this claim. We don't think it's patentable. Objections are breaking the patent office rules, okay, meaning they're not either phrased correctly, the formatting, the wording, the style, and the format is incorrect, okay? So rejections are, and to just be plain speak, are more challenging to respond to, right? The specification is objected to. So you can see there's an objection. But what's nice to hear is that the drawings were accepted. So there's nothing necessarily wrong about the drawing. So we know that the objection is about the wording. Usually it's about the written description and the way that the claim is written. So we'll go over this fairly briefly. I know we're getting in the weeds, but this is important for you to understand. In the specification, which is just the fancy word for written description, this is what the examiner had a problem with. There was a rejection on 35 U.S.C. section 102, and you can read through that, right? The current laws as of the filing date, it's going to be the AIA, American Invents Act. And this means that you cannot, you have to have a new invention. This is a novelty rejection, meaning that the examiner is saying these claims, 1, 2, 9, 10, 12, 15, 20, and so forth, are rejected as not being new. So what they're saying is it's anticipated by Suzuki. So Suzuki is the name of a author or the inventor of this patent application. And they've listed a US 2014 publication, meaning this was available to the public prior to the filing date of this invention, of this application. All right, and the examiner is going to go through, and now they're citing that this Suzuki reference has one or more cameras, has a display apparatus, has memory, right, has all the things, every single element that's in the claim of the one we just looked at, okay? And I'll skip over a lot of that detail, but you would need to read through that, of course, to be able to adequately respond to the examiner to see what they're saying and how they're arguing that it is indeed anticipated. Okay, so looking at this now, they're also rejecting under 35 U.S.C. 103. They're saying, well, it's even, it's not only not new, but it's obvious. It's obvious. And they're saying that it's unpatentable because of Suzuki and also Tam et al. So it was a separate earlier, 2007 publication. So you're taking both Suzuki and Tam. And the examiner is saying, look, even if you're able to argue with me and tell me and convince me that this is new, I'm saying it's obvious. It's an obvious version of basically to put these two things together and come up with the invention that you're now claiming. Okay, so it's the 103 rejection. So 102 and 103 are very common. And you can also see there was some objections too in here. So that is, how it will wrap up. There's usually a conclusion saying that an inquiry or communication to the examiner should be directed right to this individual examiner. There's one examiner for every patent application. And they'll give their phone number and their supervisor's number, right? So it's very, personal. And they do take real careful. And so the examiner will sign electronically and their art unit, which is technically, related to the invention field. Yeah. And there's also a primary examiner assigned to it. So that is how the attorney and their team will respond to that office action. And so there's a lot of back and forth. So you can see this is the non-final that we had pulled up earlier. That's the issue. So we have the non-final. I want to make sure I kind of round this out. And again, I'm just looking this up live with you, so I do apologize for let's see here. Let's take a look. There's just so many links here. Thanks for your patience, everybody. So the non-final, here it is. Sorry, thank you, right here. So February 28th was the non-final, okay? And so then we have all the citations, the response from Apple came in right here, okay? The amendment and request for reconsideration after non-final. Okay, let's take a really, and here are the revised set of claims. You see they went back and they revised the claims. Underlining, when you underline this, when you're adding new claims, right? You're adding subject matter, so they're trying to narrow their claims a little bit and try to overcome the rejection. Whenever you're adding subject matter to a claim, it means you're actually getting narrower rights. Okay, so after that adjustment and amendments to the claims, the examiner came back and said, you know what? This looks good. We're going to allow it. Allow it. And so this is what all inventors are looking for, is this notice of allowance. Notice of allowance. And that says, okay, I've looked at everything here. I'm going to allow this to go to grant. And that's what happened in this case just a few months later. All right. I'm going to go back and stop sharing. Thank you guys for that adventure down Office Action Lane. That was cool. I did kind of a live tour for you. I'm glad we had some viewers on too. We've got a few minutes left, so send in those live questions about what I just showed. I'm going to jump to avo.com where I've got one question on patent law and a few on trademark. And so I will do that right now. Okay, so patent application question. This first one is out of Fort Myers, Florida. And I'll put the question in the comments just so everyone can see that. All right. Oh, okay, we had a question here. David Freeman. What's better, a design patent or a utility patent? Of course, it depends on what your invention is, okay? If what you have invented, David, is functional, it has actual utility in what it does, and if what it does is unique, then utility patents is going to protect you first and foremost. Now, if your invention also is an article of manufacture, I mean, you can actually touch and feel it, or it's a mechanical product. If the shape alone, if the shape of that product and device is unique, then you should also proceed with design patent, okay? But it sort of depends on what the core novelty is about what you've invented. And if it's functional, if it does something unique, you ought to go after utility. That's what's better. But if what it looks like is actually what makes it unique, just the aesthetics, right, the ornamentation of that, then you should go after a design patent. So hope that helps. All right, I'm going to show the question here. I have a product on my patent and I made improvements. I have a patent on my product and I made improvements to it. Can I extend the patent protection years? I want to start a new advertising program and I want to include the changes to our product. Unfortunately, if the patent has granted, you cannot extend the term. All right, that is just the rule. Okay, you're going to be set with, on the utility side, 20 years from the date of filing. On a design, you'll get 15 years from the date of issue. So if after it's issued and you've come up with the next improvement or the next modification, you will need to consider filing a new patent application. What is important to note is that your current product will act as what's called prior art, will act to inform the examiner about the state of the art. And so your improvement will have to be novel and non-obvious, above and beyond your own product. So that is why it can be a challenge. And we always advise inventors before they issue, before they allow that first invention to issue, that they really thoroughly consider filing a child patent. Okay, and that's a continuation, a divisional, or a design application before the parent issues. It's really important to do that to build your portfolio, because if you file that child patent application on modifications or improvements before that first parent issues, you don't have to overcome novelty and non-obviousness on your base parent. You get to actually use the priority date way back of when that parent was filed. So it's such a huge benefit and something that we definitely advise our clients to do here at Bold Patents. You're welcome, David. And thanks for that question out of Avo. Just one or two questions I think we can pull off here. We have one question on the trademark side. I want to see if I can find a good one. So here is one. This is also, it's out of Monroe, Louisiana. Okay, here we go. So here is a question. I'll put this up on the screen too. Looks like a slogan question. Okay, yeah, I have a slogan that I think could be very lucrative if I use it correctly. How do I go about protecting it? I don't want others to be able to infringe upon or capitalize off my original slogan or phrase. Okay, cool. Well, the idea of a slogan, and protecting it under trademark law is that it must be attached to a good or service that you're selling. So if you're selling, let's say, ribs, I just see you're from Louisiana, it has me thinking about barbecue. So let's say you're selling ribs and you've got this great slogan, sauciest ribs in town. I mean, maybe that's what it is, okay? Sauciest ribs in town. If that's your slogan, you need to be able to show that either digitally online or actually having a physical billboard right in front of your barbecue stand that has that slogan there. And you have to be able to prove that you're using that to deliver the goods, right? The actual product, the ribs, the barbecue that you're selling. And if you can demonstrate that to the trademark office, you can get a registration for that slogan. Now, there are quite a few requirements to getting there. In order to be registrable, it has to be distinctive. I mean, you can't have anything too similar or close to someone else who is already using that slogan in the same class. So if someone has already captured the tastiest or the sauciest ribs in town, and maybe they've used that in some other state, but they have federal registration, that would prevent you from getting a federal registration, even though you're operating in a completely different state. So there's a lot of layers to that, but slogans can definitely be protected, but they must always be attached to a goods or services. You can't just lock down the phrase alone without providing evidence of actually being in commerce, right? The trademark office wants to and encourages and rewards those entrepreneurs that actually go out and serve customers, serve clients that are using that mark in commerce. All right, so keep those questions coming. I've just got another minute or two. I want to take one more question. Let's do that. Let me jump over. And I see a few more people hopping on live. If you did miss this, I am here every week, every Wednesday, 9 a.m. Pacific and noon on the East Coast. So if you missed it this week, catch me next time. I want to answer your live questions. Those are the best. This question here is a little bit lengthy. Okay, let's go to this one here. All right. So this one is a phrase. I have a phrase that I want to use as an acronym that I created. Do I have to patent or copyright for others to use in the future? I am an inspirational and motivational speaker and the CEO and founder of Sonia Speaks Incorporated. I have a phrase that I would like to use as an acronym that I created. So very similarly to the last question that was asked, if you have a phrase that you would like to protect, the wording of that is not something for patent law. It's more akin to trademark law. Again, if you can associate it with a good or service, that's the way to go. Copyright is valid, okay, in terms of publications of written works or spoken word or musical compositions can be captured under copyright law, but they don't provide the same level of distinctiveness, and they'll allow you to have that exclusive right in terms of competing in commerce that a trademark law does. So that'll be the way to go for you as trademarks as well. David, final question. If I file for a design patent, can I later bump it to a utility patent? The answer is yes, you can do that. Okay, so if you file for a design patent, the catch is going to be, and the tricky part is, did you adequately have enough in the disclosure? So it's not something we recommend, right? Because in order to have a utility patent application and claims, you've got to be able to have a substantive, ability to base those utility claims on in the design. And in a design application, all there is are pictures. Okay, they're figures, very carefully drawn, three-dimensional figures. So I do not recommend you do that. The answer is technically yes, but I don't recommend that you do that. I recommend you file the utility first, and then potentially add the design on later, or file both at the same time if you're not sure. Okay, David, feel free to give me a follow-up question if you have anything that I didn't get to. Here's my email right there. It's been a pleasure being with you guys. It is the end of our time together. I just gave out my email, so please do send that. I'll have this link here again. If you want to schedule a screening session, if you think now is potentially the time to get started and you want to see if now is and if we're a good fit for you, that is the link right there to schedule. Thank you, everyone, for having me on and for being part of this viewership community. Have a good day, everybody. Go big, go bold.